now in session.
Thank you. Please be seated. Good morning. We're on the record for oral argument in CV21 0509 Doe versus Arizona Board of Regents. As you know, we record and live stream these proceedings, so please give your name and the name of your party before you begin. You'll each argue from the podium and have 20 minutes per side. We ask that you keep track of your own time, including any time you want to reserve. You certainly don't need to use all of your time, and keep in mind that we have read the briefing, studied the record, and conferenced this case prior to oral argument. So with that, Counsel, you may proceed.
Thank you, Your Honor. Good morning. May it please the Court, my name is Mick Levine. I'm counsel on behalf of the plaintiff appellant in this particular case. This case involves a window legislation. Window legislation was opened in sexual assault claims in order to try and address a situation that is very important, and nationwide window legislation has been something that has been occurring across the board. This particular window legislation was passed by the legislature in a session. It was unanimously passed and signed by the governor. Now, unfortunately, what we have is a session law. The session law did not make it into a particular statute under which this case arises. The session law, however, does have the force and effect of law. What the questions are in this particular case, however, is whether a notice of claim is required in order to bring a case against the state of Arizona or one of its political subdivisions. Another question in this case is whether or not the facts of this case, as alleged, are sufficient to make a claim under the window legislation. Handling the first question first, I'm going to talk about whether a notice of claim is necessary. In order to determine the legislature's intent when they pass this law, we have to look at the plain language of the law itself. The law itself actually spells out what is required in order to bring a case under the window legislation. It says, notwithstanding any other law, a cause of action for damages described in subsection A, paragraph 1 of this section, that involves sexual conduct or sexual contact, and it would be time barred under section 12514 Arizona Revised Statutes as added by this act, or that would otherwise be time barred because of an applicable statute of limitations, a claim presentation deadline, or the expiration of any other time limit is revived and may be commenced before December 31st, 2020. So when we're looking at this language, what we're trying to determine is a notice of claim required in order to bring a case prior to December 31st, 2020? By the plain language that the legislature chose to use in enacting this window legislation, a notice of claim is not required. And I want to highlight a couple of the clauses that they utilized here. One of them says, notwithstanding any other law. That gives plain legislative intent that it doesn't not matter what other statutes are out there, notwithstanding any other law. They didn't say notwithstanding a statute of limitations. They did not say notwithstanding 12514. What they said was any other law. It's plain that what the legislature intended in these circumstances was, despite any other law, including the notice of claim statute, an action may be commenced.
But that clause is referring to commencing an action, right?
That is exactly what it says. It says a cause of action for damages, and then if I can move down a little bit in the statute, it says may be commenced before December 31st, 2020.
And a cause of action is commenced by the filing of a complaint, correct?
That is correct. A cause of action is commenced by filing a complaint in the Superior Court in the state of Arizona. It's not commenced by filing a notice of claim. And that's why we believe that the notice of claim is not required in these particular types of cases when it involves the state or a political subdivision of the state.
It's a tougher argument, though. Yeah, I think you'd have an easier argument on this statute if the session law applied specifically to claims against state entities. But apparently it even purports to apply to claims against the federal government. I'm not quite sure how that works, but it applies to everyone. And if it applies to everyone, it would seem to me that the usual and customary impediments, if you will, to litigation would have to be specifically mentioned before you could just say that they don't apply in the case of a state government entity. And that was poorly phrased, but do you know what I mean?
I have an idea, and I want to see if I can address it.
What I'm getting at is you have a law that's very broad that applies to all cases based on a certain subject matter, not the identity of the defendant.
And I'm not necessarily certain that I agree with you, and I'll explain why.
Please do.
The statute talks about a person, and that's in subsection C that we'll talk about in a little bit, but a person as defined by this window legislation includes the state of Arizona and any governmental agencies.
Sure.
Political subdivisions, private corporations, it includes pretty much everyone. So the statute was intended to apply to the state of Arizona itself.
Well, no question, but it was also intended to apply to every other kind of defendant. And so if you are, say, bringing an action against a private school, and you have a contract with that school when you enrolled that includes the arbitration clauses that we all must bow to, wouldn't that arbitration clause still have force under this law?
I believe that what this statute says is notwithstanding any other law. Arbitration clauses have force and effect in Arizona because there's a law that gives them force and effect in Arizona and permits them to take place. And
well,
notwithstanding even the arbitration laws of Arizona. Private contracts, that's not my case, so I haven't looked at that issue.
Right. It's a hypothetical. It may not have been the most artful one, but you get what I mean. Other impediments that may exist in other types of cases are similarly not mentioned here. And as I read the language of the statute, it seems to me to apply to the time bar that would otherwise apply and sweep that away. But it is not an open invitation to the court to participate in a judicial proceeding despite any other barriers that may exist to filing.
And I believe that the other barriers that you're talking about, such as an arbitration clause or what have you, may not have been specifically mentioned in the statute, but a notice of claim was actually specifically mentioned in the statute. It says, despite a claim presentation deadline. Claim presentation deadline refers to a notice of claim. Is there any other claim presentation deadline that applies?
Isn't a statute of limitations?
A statute of limitations is specifically mentioned in the clause right before that. And so we have to give full force and effect to what the legislature says. We wouldn't believe that the legislature intended to just repeat itself by saying it's statute of limitations and a claim presentation deadline. So they must have been meaning something else. And in this particular instance, they're referring to a notice of claim.
But we can't read that to say that despite the fact that you blew your first accrual deadline for your notice of claim, we're going to open up the ability for you to file an action against the state, which would by its very nature include a notice of claim in the case that this statute's opening up the ability to present to the court.
And I think in order to do that, we kind of have to look at the notice of claim statute itself. The notice of claim statute itself says that a claim accrues when a person knows or should know that they have a cause of action, not that a cause of action has been reopened by window legislation.
But isn't that exactly what this statute did, is say we're putting you on notice that despite the fact that deadlines have passed, you do have a right to sue as of today. You didn't have it before, and so today you know that you have a right to bring a claim with the subject matter involved as of the date of that this statute went into effect.
And I would say that this statute does give notice to the public that you have a right to bring a claim, but I would also say that this statute also says despite any claim presentation deadline, you can bring that claim.
But the claim presentation deadline shows up in a list of provisions that might time bar an action. And so if you blow your notice of claim deadline, it's revived.
That's correct.
Under this. But that doesn't mean it's eliminated. And that's my concern.
And I would disagree with that, and I'll explain my disagreement is because this says, notwithstanding any other law, a cause of action for damages may be commenced. It doesn't say that we have to now do a notice of claim.
Might that be reading it too broadly, though? I mean, I think of another one. Let's say the case is against a doctor. Do you still have to comply with 122602 through 122604? I would think so.
I don't think that those
Preliminary
are...
affidavit?
I don't think that those are claim presentation deadlines. I don't think that those are statutes of limitation. And as far as if the claim was against a doctor, it probably wouldn't be medical malpractice, and it probably wouldn't involve a standard of care. It would probably be something along the lines of what's mentioned in paragraph C here. So the affidavit of merit requirement probably wouldn't apply. So what I think this statute was intended to do was to be very broad. As a matter of fact, this statute is intended to bring claims, recommence, revive claims. That's the language of the statute itself, that were otherwise time barred. It doesn't say that you have to file a new notice of claim or a notice of claim as of the effective date of the statute or anything of the sort. If it had, that would be a different story. But what we're looking at is, when did the cause of action accrue? Well, in this particular case, it accrued when my client turned 18 plus 180 days. It did not accrue when the statute passed. That accrual deadline had already passed. This statute revived his claim, notwithstanding any other law, and despite a claim presentation deadline.
I understand all that, but then how do you get to the notion that you don't have to do a notice of claim at all? I mean, perhaps the timeliness component of a notice of claim is impacted by the statute, but I don't see anything that says you don't have to do one, because after all, Deer Valley tells us that public entities are just itching to settle these claims for some certain demand, and they need that right. That was a condition that the legislature created when Arizona waived sovereign immunity. So it's a pretty core concept to our law, and an implied repeal, which is basically what you're arguing without mentioning that, it seems like a stretch.
I don't think that's an implied repeal. I think that's a specifically stated repeal when it says despite a claim presentation deadline. I mean, what other language could they have meant? What other claim presentation deadline could they have meant?
It means you get to be late with your notice of claim. I don't see that it means you don't have to do one.
I don't see that it says that we do have to do one. And the way that I read this, it says notwithstanding any other law, which would include the notice of claim requirement, a cause of action for damages may be commenced before December 31st. So I understand what you're saying is that then we have a policy for notices of claim because Deer Valley indicates that supposedly these public entities want to settle claims. But when the legislature speaks very clearly as to a particular point, I believe that what they've done here is that they have said, despite any other law, we're going to permit these claims to go through. And this was a remedial statute, and it's entitled to broad interpretation. I want to get to the next point because I do see that my clock's still running. So let me get to that, which is notice to ABOR. As I understand it, ABOR is the body politic that is in charge of the universities. The universities themselves are not political entities sufficient to be able to file lawsuits against. You cannot file a lawsuit against the University of Arizona or Arizona State University. It's brought against ABOR. ABOR, as the body politic that's in charge of the universities, is the appropriate body to sue. ABOR in this particular instance is above the University of Arizona. We know that the University of Arizona, from our complaint, indicates that they are the ones who administer the 4-H programs. In this particular instance, 4-H program was administered through a volunteer or an employee. We're not sure Ms. Padilla's exact involvement, but we alleged both in the complaint. And I assume that discovery would bear that out. And Ms. Padilla knew several things about this particular situation. He knew that the gentleman in question, Mr. Torres, spent a lot of time alone with the minor in violation of 4-H policies. She knew that Mr. Torres called the gentleman at issue in this particular case, the plaintiff in this case, one of his slaves. She knew that there were used condoms on her property. She knew that Mr. Torres used her truck and her trailer without permission. All of these fit within the definition of misconduct. And I want to talk about Section C of this window legislation. A cause of action revived pursuant to subsection B of this section may be brought against a person who was not the perpetrator of the sexual conduct or sexual contact if that person knew or otherwise had actual notice of any misconduct that creates an unreasonable risk of sexual conduct or sexual contact with a minor by an employee, a volunteer, a representative, or an agent. Now, first I want to talk about person. Here, the person is ABOR. Second, I want to talk about not being the perpetrator. We don't believe that ABOR was the perpetrator. We believe Mr. Torres was the perpetrator. Mr. Torres was either an employee or a volunteer of 4-H, and through that, the University of Arizona back to ABOR. Knowledge by an agent is knowledge by the principal. I want to illustrate this point by giving a particular example. A clerk at a grocery store learns that there's a jar of pickles on aisle 6 that has busted and has covered the floor. The clerk, she forgets to go and clean up that spill. Along comes somebody who walks into that jar of pickles, they slip, they fall. The clerk has actual knowledge that there's a spill on aisle 4. We don't sue the clerk. We don't even sue Fry's if that happens to be the grocery store. We sue Kroger, which is the company that's in charge here. Yes, it's a couple of levels up, but the clerk's knowledge is imputed to the company that is in charge of it.
Why wouldn't you sue the clerk?
You wouldn't sue the clerk, just like we wouldn't sue the Padillas in this particular case. What we would do, though, is we would sue the person who is the principal. We wouldn't sue necessarily the agent.
Are you saying that's because of the effect of this session law? Because normally you would sue the clerk, right? That's how you get to vicarious liability. It would seem risky not to sue the individual who had committed the acts in question.
If the person is acting within the course and scope of their agency, then the principal is responsible for what the agent does or knows. That's our point here.
Yes,
is that the principal is responsible for what the agent knows and doesn't know. And in this particular case, the agent is the Padillas. The Padillas as agents of 4-H, the University of Arizona, and ABOR gets us to ABOR. We don't have to know that the president of Kroger received a letter indicating that there was a spill on aisle 4. Just
6,
like,
I think.
6,
But,
4,
you know.
whichever. What we do need to know, though, is that one of Kroger's agents knew about it. And what the state of Arizona is saying here is that we aren't responsible because the board itself did not know. The board doesn't have to know. In fact, the board, as an agency of the state of Arizona, can only operate through its agents. It's not a person who can be charged with having knowledge.
Well, I don't mean to do a full review of tort law right here, but it seems to me that normally you would sue the clerk and then you would sue Kroger under the doctrine of respondeat superior. Under this session law, you now have a direct action without the need for respondeat superior against anybody who had knowledge. But again, if you're going to bind the principal, you have to prove the agent's conduct. And this law may change that.
And I believe
Is that a fair statement?
I believe that's a fair statement,
Okay.
yes.
Okay.
And so because the Padillas had knowledge, ABOR is charged with that knowledge. And because ABOR is charged with that knowledge, they can be bound in this particular case. And that's how we get to liability against ABOR. I see that I only have a minute left. I'm going to save that for rebuttal. Thank you.
Okay, sure, thank you.
Good morning, Your Honors. May it please the Court, my name is Rebecca Baines. I'm here with my co-counsel Claudia Collings, and we represent the Arizona Board of Regents. This Court should affirm the dismissal of the appellant's complaint. We agree with the issues that are before this Court, and I would also like to address each of them, but I will begin with today with the issue that was the bulk of the discussion before, and that's whether a notice of claim was required before the appellant could submit a complaint in this case.
You would agree that if this Court agrees with your colleagues' reading of the session law that no notice of claim was required, you would agree that the action was timely commenced, correct? Because the complaint was filed before December 31st.
If this Court were to hold that the notice of claim statute is essentially null with these claims and accept their position, then yes, I believe the complaint was timely filed because it was commenced before the December 31st deadline. But we do not agree with their position, and a notice of claim was required. The legislature, when it passed House Bill 2466, it did not either explicitly or implicitly alter or repeal or amend in any way the longstanding notice of claim requirements that do apply to all claims against government entities. And this silence, this lack of any language, has to be read as a deliberate legislative intent. I believe it was discussed that an implied repeal is not favored. So because the legislature could have chosen to somehow amend the notice of claim statute, it could have included explicit language in the House bill saying that claim presentation requirements do not apply. It could have done that, but it chose not to do so. And so we are left with what is in House Bill 2466. And to look at the actual language of the House bill, I think that the appellant is reading too much into the notwithstanding any other law language, and is kind of ignoring that would otherwise be time barred because of language. So what the statute says is that notwithstanding any other law, a cause of action for damages that is, I'll skip a little, that would be time barred under ARS 12514 or because of an applicable statute of limitations or claim presentation is revived and may be commenced. That is, it revived claims that were once dead, essentially, that an earlier deadline had been missed. But the mere reference in this statute to a claim presentation deadline did not say that these new revived claims are not subject to claim presentation requirements going forward. That's reading something into the statute that is just not there. The legislature, again, could have chosen to include that, but did not do so. And I think what happened in the California cases that are cited in our amicus response is a good example of this. A similar thing happened several years ago. The legislature added a new statute. It created an extended statute of limitations for child victims of sexual assault. It also included a revival window for claims that were barred because of a statute of limitations, just a statute of limitations. The California Supreme Court said, notwithstanding the fact that the legislature passed this law and the apparent purposes behind this law, the claims are still, if a claim brought under that new statute is brought against a government entity, it's still subject to those claim presentation requirements. In direct response to that, the California legislature amended its Government Claims Act. That amendment was done in 2008. It specifically exempted those claims from notice of claim requirements. If the Arizona legislature wanted to do something similar, it could have done so. But absent language to that effect in House Bill 2466 or an amendment to ARS 1282101, we cannot read that into the statute. So for all of these reasons, the Superior Court was correct in concluding that a notice of claim is still a necessary prerequisite to filing a revived claim under 12514. So then we can look at the actual notice of claim that was filed in this case. And the question becomes whether it complied with ARS 1282101. And it did not, and for two different reasons. The first is that it was untimely. We've talked some about the accrual date. So the accrual date in this case was when the legislature, or when House Bill 2466 became effective as an emergency measure. And that was May 27th of 2019. So from that date, under the terms of the notice of claim statute, he had 180 days to file that notice of claim. And that puts you at about November 23rd of 2019. And yet the appellant waited almost an entire year until October of 2020 to file his complaint. And I know that the appellant's counsel raised this argument that it first occurred when he turned 18 and 180 days or after, based on the sort of traditional language in the notice of claim statute. But I think with subsection D of ARS 12-821-01, which is the provision that gives minors 180 days until after their 18th birthday, and does the same thing for individuals with disability, it gives them 180 days after that disability ceases. So you can see the way that statute works is it recognizes that this sort of traditional or normal definition of accrual that is applied does not necessarily apply in all cases. So if we're going to give effect to every provision of ARS 12-821, we must determine an accrual date to determine if the notice of claim in this case was timely. So the effective date of the statute is really the only rational accrual date that can be determined, and using any other date would just be an arbitrary exercise. So for that reason, the notice of claim did not comply with the notice of claim statute, and the complaint was properly dismissed on that ground. And then I would also look at the actual facts that have been alleged. And there's two issues here. And one is whether the facts that were alleged in the notice of claim were sufficient to comply with the notice of claim statute. And then there's a separate question of whether the facts that were alleged in the complaint were sufficient to state a claim. But to try to still focus on the notice of claim issue, should this court somehow find that the notice of claim was timely, the facts alleged in that notice of claim were insufficient. And the notice of claim requires claimants to give the public entity sufficient facts to understand the basis of liability against that entity. When you look at the notice of claim here, it's less than 3 pages long. We attached it in our appendix to the answering brief, and there's simply no facts alleged about the Board of Regents. And you even heard that in the appellant's argument this morning, that none of those facts alleged relate to the Board of Regents. The notice of claim itself talks a little bit about the 4-H program. It talks a little bit about the PIDIAS. It talks about the abuse that the appellant suffered, but it does not talk about Board of Regents. It does not allege how it's connected to any of those. It does not allege that the PIDIAS were an agent or an employee of the Board of Regents, for that matter. So for all of those reasons, the facts that were contained in this notice of claim are simply insufficient to comply with the statute. So for that reason as well, the Superior Court correctly dismissed the complaint. And then I'll turn to the final issue. If this court does agree or does disagree that the notice of claim in this issue was either not needed or was sufficient, it can still affirm the dismissal based on the complaint. The Superior Court dismissed the complaint because the appellant failed to state a claim, and the complaint in this case was almost as bare as the notice of claim when it comes to facts alleged about the Board of Regents specifically. And once again, it alleges only tenuous at best connections between the board and the PIDIAS and any knowledge that the PIDIAS may have had. It does not specifically allege that the PIDIAS were in fact agents of the Board of Regents. Rather, it does nothing more than assert conclusory statements and legal conclusions, all of which our Supreme Court has held is insufficient to state a claim upon which relief can be granted. So I am happy to answer any questions if this court has any. Otherwise, we would ask that this court affirm. I don't think so. Thank you, Your Honors.
With 1 minute left, if a notice of claim was required, when was it required? They say that it was accrual at the point in time when this statute was passed, but there's nothing in this statute that indicates that. Reading the notice of claim statute in combination with this, you still can't get to when this statute was passed. That's when the notice of claim, or that's when the case accrued. At best, what you have from this window legislation is that an action for cause of damages is revived and may be commenced before December 31st, 2020, which means that a notice of claim would be due in order to commence this action before December 31st, 2020. Thank you.
Okay, thank you. Thank you for your arguments. We'll take the matter under advisement and issue our decision in due course. We'll stand in recess to reset for the next argument.